Be trying to put our committee page.
Okay, we're live.
All right, welcome back to break, everyone. After a quick technical, we are here to pick up work on H1. And to open the conversation, I would like to invite up Madam Clerk of the House.
Hello. Hello.
We'll see you. Good morning.
Hi, Stephanie.
Thank you for having me. For the record, my name is Betsy Ann Rask and I'm clerk of the house. And I am here in my role as clerk to discuss with you the H1 amendment proposed by the members of the House Ethics Panel, because I believe it corrects an infringement on constitutional legislative authority that is set to take effect in September of this year, pursuant to last year's ethics bill, which was H 875, and which, once enacted, became 2024 Act 171. I'm also here in my role as co-counsel to the House Ethics Panel. My panel co-counsel, Deputy Chief Counsel Michael O'Grady, is the legislative counselor who is now handling H1. And Michael and I discovered during 2024 adjournment that the provisions of 2024 Act 171 appear to us to infringe upon constitutional legislative authority and procedure, and therefore violate separation of powers. And the members of the 2023-2024 House Ethics Panel agreed, and that is why H1 was introduced by those specific members. But House committees and panels are only agents of the House itself. They are under the House's constitutional umbrella, if you will. So the provisions of law that you are reviewing in H1 that apply to the House Ethics Panel, as well as the Senate Ethics Panel, ultimately relate to each chamber's constitutional legislative authority and procedure. So I'm happy to be here to discuss with you constitutional legislative authority and procedure, which are the legislative powers at issue at H1, because those are the focuses of my legal practice now in my current clerk role. But I'm also here to provide you with some context and background, because before I was elected clerk at the beginning of the 21-22 biennium, from 2010 to 2020, I was an attorney in the Office of Legislative Counsel, handling government operations. So this committee and your Senate counterpart were my home base for a decade. And in that role, my legal practice included providing advice and guidance on Vermont state governmental structure, including separation of powers. And it was in that Ledge Counsel role that I drafted the 2014 House resolution that created the House Ethics Panel. And Michael O'Grady and I have been staffing the panel together since that time. And it was also in my Ledge Counsel role that I drafted legislation to create the state's Ethics Commission. I started drafting those bills in 2015, and the Ethics Commission was finally created in law in 2017. And I handled legislation and provided legal advice and guidance on the scope of the authority of the commission, including as it related to other areas of state government, for both government operations committees and for members until I was elected clerk in 21. And since I've been clerk, I continue to handle these legal, policy, and procedural issues regarding House member ethics in my role as clerk and panel counsel. And so I've been listening with interest to the testimony that you've taken on H1. And I provided you with a memo regarding issues H1 attempts to address. And portions of this memo will also address testimony that I've heard provided on behalf of the commission. And that testimony has included the following concerns to me that I'll flag for you. And I'll provide an overview now of some of those concerns. First, that the commission is somehow not part of the executive branch. It is, not only in statutory law, but in reality, regardless of whether statute says it's in or of or nothing at all. And it's a flag for me that the commission, as I understood the testimony, does not understand where they fit in Vermont state's governmental structure.
Excuse me. Is there something the gallery would like to speak to right now? I'm just seeing some mannerisms and some chatter going on.
I wasn't chattering, I was just shaking my head. because I
Yes,
just don't
so
agree
could
with
we
that.
maintain decorum, please, from the gallery? Please proceed, Madam Clerk.
Thank you. That was one. Two was that the commission does not have enforcement authority, as I understood the testimony. It does. Beginning September 1 of this year, the commission has full investigative and enforcement authority, including subpoena power and the ability to issue public warnings and reprimands when it determines that there's been a violation of the code of ethics committed by a public servant. Three, that this new consultation requirement that's at issue in H1 does not somehow apply to core legislative duties. And this consultation requirement does. The commission, I believe, should know in its enabling law that it makes no distinction regarding whether a complaint involves core legislative functions. The commission, by its statutory law, is required to refer all complaints to the chamber's ethics panels. And this consultation requirement that was enacted in last year's bill that attempts to control the panel's procedure before they act on any complaint of the panel that the commission refers to a panel applies to all complaints. And furthermore, to confirm, we in the panel and as panel staff do not yet know at this time where the commission draws the line between what constitutes a core and non-core legislative duty. We don't know that yet. So under the commission's interpretation of the law, as I understand it, which does not match the plain language of the law, we do not know when the commission would or would not expect the panel's predisposition consultation then. And finally, the fourth thing I heard in testimony on behalf of the commission, that this legislative process feels rushed. To that I say, I can relate. The matter that is at issue at H1 is derived from 2024's 875, which this committee introduced, in which the House considered for the first time on March 29th, 2024, as we were nearing the biennium's adjournment. And as Michael O'Grady mentioned, neither the panel, the House Ethics Panel, nor its staff were ever asked to weigh in on the bill's procedure that directly impacted the panel. If we were, we could have been having this conversation last year, before the bill was enacted, and not now. The Senate didn't pass it until May 10th, which was the very last day of the regular session. They messaged back to the House a proposal of amendment, and the House took it up with the rules suspension and concurred in it on the very last day of session. And for the members who were here last biennium, you'll likely recall that the focus of the House's floor debate was on the new requirements for municipalities and the municipalities' compliance with the new municipal code of ethics that was enacted in last year's bill. That is my recollection of the focus of the debate. It's what the roll calls were on. What was a flag for me as I was reviewing the language for the first time on the floor was that this committee was proposing an expansion of the commission's powers to include those new municipal ethics and new investigative and enforcement authority. But the House agreed to our appropriation committee's recommendation to eliminate the full-time legal counsel that was going to be created to assist the commission with these new duties. And that was a flag for me in part because from 2008 to 2010, I was a prosecutor in the Office of Professional Regulation, handling mostly nursing cases before the Board of Nursing. So I'm familiar with the general structure that's required for executive branch agencies performing administrative law functions. And that normally includes an investigator, a prosecutor, board counsel, and an executive director to oversee the program. And what was sticking out to me was with the commission now with these new duties still has only its part-time executive director and administrative assistant. So that was a flag to me, and what we did not see at the time, and we didn't see until after enactment during adjournment, was this new consultation requirement that is the subject of H1, and it is that limited issue in H1, just the consultation requirement that's H1 is attempting to address. So that's why we're here flagging this for you now. flagging our constitutional concerns with this language, and providing for you what we think is a constitutionally sound alternative to meet the same spirit and intent prior to this language of last year's bill taking effect in September of this year. That's the purpose of the H1 amendment proposed by the House Ethics Panel members. So with that background, let's get into it. Mr. Chair, may I please share screen?
Yes.
Thank you. I'm going to pull up the memo through the wonder of our awesome committee assistant staff. It's posted on your committee page. Is it showing up here?
Yeah.
Technology. All right. So let's start it from the top. Your committee's been considering H1 and the proposed H1 amendment. H1 amendment is proposed by the members of the House Ethics Panel. What this memo is intended to do is to provide additional context regarding why the panel and its staff perceive the panel's proposed H1 strike all amendment to be necessary in order to correct an infringement on constitutional legislative authority and procedure created by the enactment of H75. Section 9 only. That's Section 9 amended 3 VSA 1223, which provides the procedure by which the commission accepts and refers complaints regarding governmental ethics in any of the 3 branches of state government. Under that statutory law, which existed prior to your bill becoming enacted last year, the commission refers a complaint to the applicable state regulatory entity that ordinarily handles such a complaint based on the complaint context. So to confirm, in the legislative branch, the commission refers complaints regarding representatives to the House Ethics Panel, and it refers complaints regarding senators to the Senate Ethics Panel. In the judicial branch, the commission refers complaints regarding judicial officers to the Judicial Conduct Board, and it refers complaints regarding attorneys to the Professional Responsibility Board. And these are the regulatory entities that are the arms/agents of the state constitutional entities that have authority over these individuals in accordance with, you're going to recall this language, the exclusive authority of the House and Senate to judge member qualifications as set forth in the Constitution in Chapter 2, Sections 14 and 19, and the similar authority of the Vermont Supreme Court to have, quote, disciplinary authority concerning all judicial officers and attorneys at law in the state as set forth in Chapter 2, Section 30 of the Vermont Constitution. And I just provided in that footnote 1 that the full list of the applicable entities to which the commission refers complaints is set forth in 3 VSA 1223B. There's a list there. Each subdivision of B provides which entity the commission is supposed to refer a complaint, but we're focused here just on the legislative and judicial branches. They're in B4. So 2024 Act 171, Section 9, added a new subsection C to provide a consultation requirement when the commission refers such a complaint to the applicable state regulatory entity. The new consultation requirement, as I said, is not yet in effect. It's set to take effect on September 1, 2025, pursuant to its effective date section. Subsection C purports to require each regulatory entity to consult in writing with the commission regarding the application of the state code of ethics, which is set forth in statutory law, on any complaint. The commission refers to the regulatory entity before the regulatory entity can make a final determination on the complaint. Under the statutory construct of 3 VSA 1223, the commission is an entity that, quote, shall accept complaints from any source regarding governmental ethics in any of the 3 branches of state government or of the state campaigns finance law. It is a general repository that any entity, that any individual can submit a complaint to the commission about state ethical conduct, and coming up also municipal ethical conduct. And the duty of the commission is to refer the complaint to the applicable state regulatory entity. And in drafting the commission, before it was created, that was the purpose. It was a place for an individual who was concerned about state governmental ethics to know there was an entity that is responsible for taking them in, take an intake for these complaints, and to know that somebody's tracking them. Because you can look at the enabling law of the commission and see it was a place where anybody can submit a complaint. The purpose of the commission was to track them, refer them to the applicable entities. And it involves campaign finance law, human resources, governmental conduct regulated by law, which went to the AG or state's attorney. Those entities were required to report back. In the case of the legislative and judicial branches, the statute purposefully said, request a report back. You can see it in law now, because that was an acknowledgement of the constitutional authority the legislative and judicial branches have. So as I mentioned, 2025 H1, as introduced, was sponsored by the members of the 2023-2024 House Ethics Panel who were returning to the House. We had one member who went to the green room, so he couldn't be on the bill. In order to address the separation of powers concerns regarding this new consultation requirement. These concerns were only realized after adjournment of that last year that biennium passed, because as stated, neither the panel nor its staff were consulted on these new requirements prior to bill enactment, despite these provisions impacting panel processes. The H1 strike-all is proposed by the members of the 2025-26 panel as updated language. Both the bill is introduced and the amendment are limited to the manner in which this consultation is required. When the commission refers a complaint to the applicable regulatory entity in the legislative and judicial branches due to the constitutional authority of those two separate branches. Specifically, the H1 amendment would require the commission to provide in advance any application of the state code of ethics to the complaint and a recommended action in order to avoid the 2024 Act attempt to control by statute the constitutional authorities of the legislative and judicial branches to regulate the individuals to drive the Vermont Constitution. By the H1 amendment requiring the commission to provide its consultation up front when it refers any complaint to the relevant legislative panels and judicial boards, it will address, in our legal opinion, the constitutional concern explained in testimony by the legal counsel for those entities. You heard from the judicial branches entities, and you heard from Michael O'Grady. That our concern is that the upcoming law, if not amended before it takes effect in September, attempts to control those entities before they can act on a complaint that's within their constitutional purview. Under the H1 amendment, with this information in advance, we can speak only for the House here, but for the House Ethics Panel can then consider any application of the State Code of Ethics, and the panels need to further consult with the Commission. So this memo will describe the legislative powers impacted by that Section 9 of last year's Act. And relatedly, I'll just mention, because the judicial branch can speak for itself, and they do, the judicial powers impacted by that provision. It will also provide an overview of the State Ethics Commission and the current processes that are shared between the Commission and the House Ethics Panel. So, as I've said before, when you're talking about constitutional issues, you gotta take it from the top, because the Constitution always controls. This is the supreme law of our land, the US Constitution. But what this memo describes, when it comes to separation of powers in state government, this doesn't apply. The US Supreme Court has held that the Constitution of the United States does not contain a requirement regarding how a state is to portion its power among its three branches. And that whether and to what extent a state should have a separation of powers among its branches is an issue within the state's control. This state, Vermont, no other state. It's this document. It's this beautiful document, the Vermont Constitution, that controls the operation of our state government. And we know that from Vermont Supreme Court case law. The Vermont Constitution controls the operation of our government It's the fundamental charter of our state and it's preeminent in our governmental scheme. The Constitution stands above legislative and judge-made law, and the rights therein speak for the entire people as the supreme law. And we hold it up here because it's above us. The Constitution requires in Chapter 2, Section 5, that there be a separation of powers among the three branches of state government. It provides it in Section 5, Chapter 2, when it says the departments shall be separate and distinct so that neither exercises the powers properly belong to the others. And our court, the Vermont Supreme Court, has described what those powers are. Briefly stated, the legislative power is the power that formulates and enacts the laws. The executive power enforces them. And the judicial power interprets and applies them. And separating these three core powers is a fundamental principle that serves to create a governmental structure resistant to the forces of tyranny. I love that quote because how I think about this document is like, this is the middle of the wheel. This is the heart of our government. The three branches are the three spokes that come out from it. And we just keep moving forward, steamrolling over tyranny. That's how I like to think about this. But we understand the structure of our constitutional state government from the Vermont Supreme Court. Because in the checks and balances built in the separation of powers among the three branches, it's the power of the court to decide whether Vermont's laws comply with the state constitution. It's the function of the courts to maintain constitutional government. And the Supreme Court of Vermont is the final interpreter of the Vermont Constitution. And I provided case law citations for all of these quotes. You can see them in the footnotes. So what are we talking about here in regard to the legislative and judicial branches? Well, some of this will be familiar to this committee for members who worked on impeachment, and for this whole committee working on the contested legislative election. It's going to be a revisit of some of these powers. So Chapter 2, Section 14 provides with the House with the authority to judge the elections and qualifications of their members and to expel members. And Chapter 2, Section 19 provides the Senate with like powers to do the same. And you've heard about this case, the 2001 Supreme Court Brady v. Dean case. I'm going to abbreviate Supreme Court throughout this memo as SCOVY, Supreme Court of Vermont, its official name. The SCOVY acknowledged that our Constitution does not define, nor we previously addressed the precise scope of legislative prerogative over its members' qualifications. But this exclusive constitutional prerogative at least encompasses, at least surrounds, the authority to determine whether a member's personal or pecuniary interest requires disqualification from voting on a question. That's why the House alone has the authority to determine whether a member has a conflict of interest. And the courts acknowledge our rule, House Rule 75, members can't vote on a question in which they're immediately or directly interested. And the court has stated, as a policy matter, a regard for the independence of the legislature requires we respect its members' personal judgments concerning their participation and matters before them. So, in addition to that, though, there's another issue. It's legislative procedure, and each chamber having the exclusive authority to determine what its legislative procedure is, and that's in B here. Because the only thing that controls the legislature is this document, the Constitution. As our Vermont Supreme Court stated, the Constitution is not a grant of power, it's just a limit on it. The power of the legislature is practically absolute, except for constitutional limitations. And legislative rulemaking is considered a necessary legislative power. Masons says this, and Masons is based on case law nationwide. So every provision of Masons also has case law, has citations to the basis for its provisions that are in there. And inherent in every legislative body is the right to regulate its own procedure. And while legislative procedure has to comply with constitutional requirements, such as your quorum requirements, or when a roll call is required, or the vote threshold to vote on an override a veto, legislative procedural authority is otherwise unlimited. We don't have any known Vermont Supreme Court case law that directly addressed any limits of the constitutional authority of the House to have and control its legislative procedures, but there seems to be a robust case law on this elsewhere in our United States. For example, the Supreme Court of Iowa adjudicated many of those cases, and its cited holdings have acknowledged broad legislative procedural authority. For example, I provided a quote here that legislative procedural authority of a chamber does not restrict the power of a chamber to the mere formulation of standing rules or the proceedings of the body in ordinary matters. But in the absence of constitutional constraints, the authority extends to the determination of the propriety and effect of any action taken by the body as it proceeds in the exercise of any power, in the transaction of any business, or in the performance of any duty conferred upon it by the Constitution. So I'll note that the General Assembly's chambers can follow legislative procedures set forth in statute, but statute only exists, as we've discussed before, after a bill is concurred in by both chambers, and the bill must be presented to the governor because the governor is a necessary part of enacting law. But neither the governor nor the other chamber have any real constitutional authority to control House procedure. Therefore, as we recommended, statute, whenever possible, should not attempt to control legislative procedure. And it is a principle that constitutionally permitted legislative rules and procedures supersede statute. And this is proclaimed multiple times in Masons. And this is something that I want to flag, because you can enact legislative procedure for the House and statute, but as these provisions of this memo address, the chamber can always amend its procedure and do something different. And so this is a flag that I want to flag for you in this statutory attempt to control procedure, because the statute does not control the consultation requirement, how the House needs, the House Ethics Panel, and therefore the House must conduct their procedure in consulting, does not control the House.
Maybe pause for a minute.
Yes, Mr. Chair.
I would like to reiterate what I just heard, that the House's or the Senate's own rulemaking and procedures supersedes what's written in statute.
Yes, they can at any time change, deviate from statute. And this is a flag for me, because I know when you're hearing about the issue, about ethics, you do have a lot of public pressure. I understand that. And it is compelling. You heard testimony about public perception that would be impacted by H1. And I acknowledge that. But I need to point out, Michael O'Grady and I are not here to make people feel good about you. We're here to provide you with legal advice on constitutional provisions of law. That is why we are here. So that you are aware of the constitutional provisions that apply to this issue, so that according to your oath of office, you can make the best decisions according to the best of your judgment and ability. So I'm not going to try to belabor this memo. The information is here with the case law citations. I'm going to go through some of these provisions more quickly, but what this information is saying here is that courts are not going to adjudicate challenges to constitutionally permitted legislative rules or violation thereof. It's the legislative prerogative to make and interpret a chamber's own procedural rules, and the judiciary cannot compel the legislature to exercise a purely legislative prerogative. Courts in other states have said, in this case, at the top of page 6, just as the legislature cannot invade our province of procedural rulemaking for the court system, we can't invade the legislature's province of an internal procedural rulemaking. A member of the legislature can raise a point of order regarding a violation of any of the rules of the House or Senate. That's the proper forum for determining the propriety of the activities complained of. The U.S. Supreme Court has reiterated this principle in acknowledging that Congress's constitutional authority to determine its rules of proceedings is an ongoing power. It empowers each house, the US Constitution empowers each house to determine its own rules. And the power to make those rules is not one which once exercised is exhausted. It's a continuing power. Every biennium, new members, you're not stuck with the rules that you had. You can always change them unless they're controlled by the Constitution. This consultation requirement is not. Moreover, multiple states' Supreme Courts appear consistent. Statute does not control legislative procedure. For example, in an opinion of the Supreme Judicial Court of Maine, the court found that a person contesting a House member's election failed to comply with a statutory requirement about a legislative election contest. The court stated that's not going to prohibit the House's Committee on Elections from having jurisdiction to entertain the petitioner's claims, because each chamber has the authority to determine its own procedure. The Constitution clothes each house of the legislature with exclusive and plenary jurisdiction. Legislature can provide reasonable rules of conduct in resolving election contests involving its own membership, but it always rests upon the chamber to decide what that is. Similarly, in Wisconsin, there was a claim that an act was invalid in part because prior to passage, a bill was not referred to a specific committee as required by statute, and the petitioners were arguing about the validity of the bill. The court refused to decide the question in light of separation of powers. To discuss or consider the petitioner's argument regarding whether the statute was appropriately applied to the bill would imply that this court will review legislative conduct to ensure the legislature complied with its own procedural rules or statutes in enacting the legislation. We conclude we're not going to intermeddle in what we view in the absence of constitutional directives to the contrary to be purely legislative concerns. So we're not going to resolve this question. So this next paragraph is describing that legislative rules and procedures are entirely within a chamber's control. And it described in this case, in this middle paragraph, that a statute that attempted to prescribe procedure does not remove it from the application of the general rule that the chamber can always do something different. Doesn't matter that's embodied in statute. It's not open to judicial scrutiny if the chamber didn't follow it. This has been echoed in in New Hampshire case law. More recently, they echoed a sentiment that constitutionally permitted legislative procedures can supersede statute. It's not within a court's authority to intervene if that happens. Relied on multiple cases in the nation, including from Alaska, which held that when a statute relates solely to the internal organization of the legislature, a subject that's committed to the Constitution, by the Constitution to a chamber, the judiciary is going to respect the legislature's procedure and not intervene. In another case in New Hampshire at the bottom of this page, citing other states' case law, the legislative rulemaking authority is a continuous power absolute. Chamber is not bound by action taken by a previous legislature, and the legislature alone has complete control and discretion, whether it shall observe, enforce, waive, suspend, or disregard its own rules of procedure. The same is true of statutes that codify legislative procedural rules. Statutes relating to the internal proceedings of the legislature are not binding upon the houses. Either branch, under its exclusive rulemaking constitutional prerogatives, is free to disregard or supersede such statutes by unicameral action. I'm pointing this out again because right now, the step to take effect on September 1 is that consultation requirement in statute. It is there if you don't amend it, but I'm just emphasizing that it doesn't control the House Ethics Panel procedure, nor does it control the Senate Ethics Panel procedure. I cannot speak for the Senate Ethics Panel, and I can't speak for a future House Ethics Panel. I'm flagging it due to the concerns you've been hearing about public perception in regard to legislative ethics, and I'm just flagging that there is a better way to do this that is more direct and appropriate in a constitutional manner for the House to address this issue by House Ethics Panel procedures, which it has done in another instance that I will get to at the end of this memo. So I'm just providing here for reference in C on this page behind us here on page 8. Because you heard from the judicial branch. I cannot speak for the judicial branch. They are very capable of speaking for themselves, but you've heard from them, because of this provision of Chapter 2, Section 30, the Vermont Constitution that provides the Vermont Supreme Court with disciplinary authority concerning all judicial officers and attorneys at law. And so the court has stated, while we have the assistance of the Judicial Conduct Board for judicial officers in judicial conduct proceedings, this court makes the only final and ultimate decision. And the findings and recommendations of the Judicial Conduct Board carry great weight, but are advisory, not binding. And regarding attorneys, the Professional Conduct Board acts on behalf of this court pursuant to the court's exclusive responsibility over attorney discipline, with the court making its own ultimate decisions on discipline. All right, moving on. This memo provides a high-level overview of the Vermont State Ethics Commission. You have the commission here to further provide details, but this provides an overview of the law. So first, the State Ethics Commission is in the executive branch. This is stated in the commission's enabling law. It says there is created within the executive branch an independent commission named the State Ethics Commission. But that statement exists only as clarifying language. I know because I wrote it. The commission would be in the executive branch regardless of whether that provision of its enabling law were repealed or if it were never enacted to begin with. Nor would the commission's suggestion to amend the law to provide that the commission is or is not of the executive branch be of any effect. It's executing laws enacted by the legislative branch. The Vermont Constitution does not contemplate state entities that float free from one of the three branches. Repeating again, briefly stated, the legislative power is the power that formulates and enacts the laws. The executive power enforces them. The judicial power interprets and implies them. And there's that separation of powers being a fundamental principle. The Ethics Commission is in the executive branch because it's executing the law enacted by the General Assembly. The conferred authority to execute the law is the executive power. Executive branch entities have the power to apply the general provisions of law to particular circumstances and situations. This is not true only on our state level, but also on the federal level. And I provided a citation footnote 45 to a U.S. Supreme Court case that stated interpreting a law enacted by Congress to implement the legislative mandate is the very essence of execution of the law. And the Ethics Commission is independent in the executive branch because it answers to no entity other than itself. According to its statutory law, 3 VSA 1221b4, commission members can only be removed for cause by the remaining members of the commission. As the U.S. Supreme Court stated, once an officer is appointed, it is only the authority that can remove him, not the authority that appointed him, that he must fear in the performance of his duties and functions obey. That was purposeful. The members of the Ethics Commission get appointed by different entities, but the statutory law was purposefully drafted so that only the Ethics Commission members could judge itself, be the judge of its own members, like you're the judge of your own members, and only the commission has the authority to remove a commission member. And the General Assembly has used that statutory structure to create similar executive branch entities, such as the Green Mountain Care Board and the Cannabis Control Board. You've used that statutory construction in other instances, independent executive branch entities. So, as it was originally created, the State Ethics Commission did not have investigative or enforcement authority. However, that 2024 Ethics Act provided the commission with the authority to investigate, hold hearings, issue warnings and reprimands, and recommend actions in regard to complaints effective this coming September. On that date, the commission can investigate after receiving a complaint, or it can investigate on its own initiative. And that new commission authority will include the power to enforce the state code of ethics, which is set forth in hyperlinked here, 3 VSA chapter 31, subchapter 1. While 3 VSA 1202C of the Code of Ethics provides that the application of the code, quote, does not in any way abrogate or alter the sole authority of each house of the General Assembly to judge of the elections and qualifications of its members under the Vermont Constitution, it's to be determined how the commission will view the scope of its enforcement authority in regard to House member conduct. Specifically, It's unknown at this time what the commission will be perceived to be core legislative functions that are constitutionally committed to the House, such as conflicts of interest in voting as described in Brady v. Dean, versus non-core legislative functions that the commission may provisionally regulate. For example, it's unknown at this time whether the commission would attempt to prohibit legislators from holding outside employment under one provision of the code, 3 VSA 1203 IA, or to prohibit another branch of government from hiring a legislator. I've just provided citations to what we, Michael O'Grady and I, perceive to be the constitutional provisions that restrict those types of interferences. Finally, I'm going to end with interaction between the commission and the House Ethics Panel. So once the commission was created in law, in accordance with the commission's original duty to refer complaints about reps to the House Ethics Panel and request a report back from the panel regarding the final disposition of the complaint, the House Ethics Panel amended its own procedures for handling complaints by adding a new section 7C, which provides an exception to the panel's confidentiality requirement to provide the commission with notice of the final disposition of a complaint referred to the panel by the commission. So how that happens in practice is that the panel provides the commission with a copy of the closure report that the panel provides to both the complainant and the respondent in a complaint that the commission refers to the panel. I believe I heard the commission say it doesn't understand the rationale of the disposition of complaints the commission refers to the panel. But pursuant to the House Ethics Panel procedure, which it adopted, the panel provides the commission with a copy of those closure complaints. Second, 3 VSA 1205 provides that the panel is to submit its code of ethics training materials to the commission in advance of the training. The panel has submitted its training PowerPoints to the commission for review. I believe I heard the commission testify that it has not participated in any code of ethics trainings here in the legislative branch, but I will just remind for members who were here last biennium that in 2023, the commission participated in the House training by reviewing the new gift provisions of the Code of Ethics, which is the main part of the Code of Ethics that we get the most questions about and the most applicable non-core legislative duty, because receiving gifts is not a core legislative function. This biennium, the panel invited the commission again to participate in the panel's training, but the commission was not able to do so due to a scheduling conflict. However, the commission reviewed the panel's training materials for this biennium regarding the Code of Ethics. It provided feedback, and the panel updated its Code of Ethics training materials based on that feedback. Also, the panel or its staff will refer representatives to the commission on matters that pertain to the acceptance of gifts or other non-core legislative duties. When it is outside the scope of the panel's jurisdiction, whether a gift is permissible, we will say you really should talk to the commission. What we'll also say is, if you would be willing to do so, can you please let us know what the commission says, so we can better understand the application of the state code of ethics. We want to know. When you look at the gift statute, though, you will note that there are nuances. A gift is not permissible to a legislator unless it meets one of the gift statute's exceptions. And there are nuances in the gift statute provision, such as whether a gift will, paraphrasing, be for the good of the legislative purpose. And so what we found that there are nuances to the commission's response, as we understand it, about whether a gift would help the legislative process. Finally, one of the last aspects of interaction between the panel and the commission is that pursuant to 3 VSA 1226A, as added by Section 19 of last year's Ethics Act, annually by November 15th, the panel was to report to the commission aggregate data on ethics complaints not submitted to the commission, with the complaints separated by topic and the disposition of those complaints, including any prosecution, enforcement action, or dismissal. So this was a new provision of the ethics bill. And the panel corresponded with the commission about this requirement due to the panel, House Ethics Panel, having an overall confidentiality requirement, which, pursuant to the panel procedures by the plain reading would not allow the panel to describe topics of complaints. We submitted to the commission an initial report, we meaning the panel. Thereafter, the commission provided the panel with feedback about the purpose of it asking for this information, the complaint topics. And so the panel met, and thereafter the panel followed up based on that commission feedback with a report addendum to conform to that new reporting requirement. And I'll note that panel members sponsored a House resolution this year, HR 6, provide a hyperlink to adhere to propose amendments to the House ethics rule to address confidentiality to allow topics of complaints and other matters related to disclosure and info sharing of complaint information. This is some HR 6, a House procedure, panel procedure set forth in the appropriate method of legislating, House resolution that was treated as a bill, referred to the House Ethics, House Rules Committee. And so the House Rules Committee will take up that resolution. And that I invite members to look at that House resolution because it will impact, if adopted, confidentiality exceptions and when to and to what extent the House Ethics Panel can disclose information about complaints that it receives, since it impacts 150 members. So in conclusion here at 11:30, I've taken up a lot of your time. The proposed H1 amendment is offered by the members of the House Ethics Panel to address the constitutional concerns related to last year's Act 171, Section 9, consultation requirement only, while still allowing the panel to consider and understand the commission's perspective and expertise on any application of the state code of ethics. All that H1 amendment is doing is saying, instead of a statute attempting to control legislative procedure to prohibit the panel from acting on a complaint referred to it until the panel is consulted in writing with the commission, it is just would be requiring the commission to provide information upfront that the panel can then consider, understand, and then the panel can determine where to act, how to act from there. Please let me know if you have any questions. If you'd like to further discuss. Thank you.
No, thank you very much for that cerebral yet digestible presentation, Madam Clerk. Where's everything go?
Do you have, and this is probably putting you on the spot, a particular scenario that you could describe to this committee of what might happen if the H1 amendment is enacted? How would this look? A complaint comes to the ethics panel. What happens after?
If the H1 amendment to the law is enacted?
Yes,
Okay,
is enacted.
so great. Can we look at that H1 language so we can look at it together?
Please.
Excellent. Okay, thank you.
It was your.
Let's go back to technology because I have it up here.
As introduced.
Yes, let's look at the,
The amendment or the.
Proposed amendment.
thank you.
Yes.
Oh, let me get to it, sorry.
Take your time.
The operative, but not that it's not.
That is your question to ask, Representative. I agree with where your head is at.
Sorry, I'm good. I love our bill pages, but let me just get to the right place on here. Pardon me as I navigate online. Here we go. Okay, great, thank you. Thank you again to our committee staff. Okay. Here's that console requirement. Okay. So here is, let me just back up. 3 VSA 1223 is that procedure for the commission accepting and referring complaints. So you can see how it works in practice under current law, that the commission accepts complaints from any source, and then the commission goes through a process of a preliminary review, and it refers complaints to all relevant entities. if the complaint is in regard under 4B to conduct committed by a state rep, the executive director of the commission shall refer the complaint to the House Ethics Panel and request a report back from the panel regarding the final disposition. Now, let's go down to that consultation requirement. This is saying, under that new C1, if the executive director refers a complaint under subsection B, which includes that referral to the House Ethics Panel, the executive director shall signify any likely unethical conduct described in the complaint. Here is the new language that's proposed for those B4 complaints, which is referring specifically to the complaints referred to the legislative branch and the judicial branch. The executive director shall specify the application of the state code of ethics, the facts presented in the complaint, and include a recommended action. So instead of last year's bill's requirement that would statutorily purport to require the commission to consult with the commission in writing before it could take action, this would be the commission providing in advance any likely unethical conduct described in the complaint, and then specify the code of ethics, the facts presented in the complaint, and recommended action. So the commission gets a complaint about a rep. The ethics commission would say this may or may not involve, let's pull up the state code of ethics. Here are the provisions of the state code of ethics. Conflicts of interest, directing unethical conduct, appearance of unethical conduct, preferential treatment, misuse of position, misuse of information, misuse of government resources, that amorphous gifts, unauthorized commitments, employment restrictions, compliance with laws, rules, and policies, or a whistleblower violation. So as I would envision it, the commission would say this complaint could involve one of these provisions of the code of ethics. Here's why. The complaint stated that a legislator accepted a gift that wasn't permitted by the gift statute, for example.
A car.
And the commission and the panel could then accept that information from the commission with its expertise regarding the state code of ethics, have the information before the panel when it receives that complaint, and then determine, based on the facts of the complaint and any other information that the panel gathers, whether there could be a code of ethics violation. And with that information, the panel would be able to reach out to the commission, which it has asked reps to reach out to the commission regarding issues, for example, involving the gift statute. But here, the panel would have in advance the flag concerns of the panel, and the panel can determine what to do from there, which could involve reaching out to the commission for advice. I'm sorry, Madam Vice Chair, did that help address?
Yes.
Okay.
Absolutely, thank you.
Representative Boyden.
Can we talk about the flip side of if the
Yes.
H1 amendment is not?
Yes. So again, if the amendment does not pass, let's go back. All my windows. Here we go. So if the amendment does not pass, statute would say that the executive director will signify likely unethical conduct. And the statute would say the House Ethics Panel or the Senate Ethics Panel or the judiciary entities would be required to consult with the commission regarding the code of ethics to the facts presented in the complaint prior to the entity making a determination on the complaint, meaning restricting the procedure of the legislative or judicial entity, which means either closing a complaint without further investigation or issue findings following investigation. So this would be that statutory attempt to control that legislative procedure, which the panel, and I cannot speak for a future version of the panel, and I cannot speak for the Senate Ethics Panel, and I cannot speak for the judiciary on how they would administer that statutory attempt. That's why we are emphasizing the constitutional preference for the commission to provide the information up front, so we can avoid that statutory attempt to control constitutional power.
Just to voice my understanding, they would almost take over the place of our legislative ethics panel. Not take the place, but take over some of their role and
Yes.
our role to judge our members.
Thank you. Yes, I think that's the overall concern, is that this is a statutory entity attempting to interfere with constitutional process and authority. So yes.
Any other questions for Madam Clerk?
Clear.
Thank you so much.
Thank you.
That was so useful.
I'm sorry that so much information, but I just want to make sure that you have the information and the rationale for the concern on this issue of public. Thank you.
So we selected the gallery who are with this. I am willing to let this bleed into lunch for a little bit so we can have this conversation in a responsible way. So either or both of you would like to join the table?
Would you like another chair so you can both come up together?
Yeah, that'd be good. I think that I really would like to let Larry do most of the talking because he's done all the constitutional research. TJ Jones, who spoke last time, is hoping to be here, but he had to leave to catch a flight. So he's the person who has all the perspective on what other states do. So I'm just going to try and be very quick and kind of, I think, correct some misinformation. So I'm going to start with like an issue that's been before us, which is the understaffing of the Ethics Commission. This is the first time that I heard that the House Clerk actually asked for staffing to be removed from our appropriations request this year.
I did not, to confirm, I did not ask for staffing to be removed. It was a concern, my testimony was a concern to me on the floor that the House agreed to remove your staffing without addressing your other powers, that the staffing was meant to support.
My understanding was that you had lodged an opinion that we did not have enough staffing and that it should not be, so we should not get a legal counsel.
I did not think that.
Okay, well, I heard differently, but I will say,
Regardless, it has been corrected. Please proceed.
well, moving forward, I just want to talk about, I mean, I hope you agree that you mentioned that we had enforcement powers. And so I would like to correct that, misconception. We do not have enforcement powers. So should we get a legal counsel position in our office, that is the staffing that we have determined is necessary to align with the powers that we have now, which are hearing and investigatory powers. And so the way that we intend or anticipate using these powers are for complaints that come into our office that are very low level complaints and can be resolved through resolution agreements. And for cases of complaints that come to our office that are, there's no place else to send them. So we've had a number of complaints in the past year that there's no place to go. We can't refer them anywhere. So those include commissions, state level commissions. Those include elected officers. And for example, state's attorneys last year, there are a number of situations last year where state's attorneys were in the news and there's nowhere to send the complaint. That is because the only role of the professional responsibility board is to deal with licensing. We had actually had people within government reach out to us, ask if we could take over this complaint or investigate this complaint or look into it so that findings could be at least made public, and we could not at that time. And I think it is important to note that the reason we got these investigatory and hearing powers is not because we asked for them, but because the legislature asked for them. We did not put that in our proposal last year. This was something that the legislature came up themselves because they noticed a gap. We said the minimum amount of staffing that we need to do this is going to be a legal counsel position. We also asked in our budget for money for an investigator. We do not need a prosecutor because we're not going to court. So that is a very important distinction. We do not have enforcement powers. We only have the power to make recommendations, which is what we are talking about here. We will not be taking over any of the powers or the House or Senate ethics panels. We're making recommendations and then they would decide what they're going to do with it. You said that we get reports back from the House and ethics panels. We get closure letters that say a complaint has been closed. We get no details about the complaint. The reason that this issue has come up, the consultation requirement, is because we have seen complaints come to our office that on their face involve violations of the state code of ethics that do not involve core legislative functions. They get closed out. We do not understand why they were closed out. We don't understand what the discussion was that was happening there. So this is our our purpose here is to try and educate the House and Senate ethics panels. I heard nothing that was said here today that stated that if you wanted to adopt this consultation requirement, they could. So the question is, why would you not do it? So you can adopt a rule saying like, yes, we're going to consult with the state ethics commission for, educational purposes. So if you can do this on your own volition, then what is the argument for not doing it? Because essentially all that is happening here is receiving advice about non-core legislative functions. When the State Code of Ethics was adopted, there's a lot of discussion about what constitutes a core legislative function. We submitted documents, data, research about how this is defined nationally. That was part of the discussion. It is very clear what is a core legislative function, what is not. There's a lot of case law on this. We are only going to be advising on non-core legislative functions if, for example, there's a consultation requirement issue that came up and one of the ethics panels says, no, we think this involves a non-core legislative function. In a normal working environment, you would engage and you would discuss, why do you consider there's not to be a core legislative function? Why do you consider there's to be a core legislative function? Let's see where we can come to an agreement. There's case law on this. This is not, an amorphous question, how would we do this? This is actually a definable term that was discussed when we adopted the State Code of Ethics. The State Code of Ethics exempts core legislative functions. We can refer complaints on any topics, but we can only consult on the State Code of Ethics, right? So we're talking about, I'm going to leave this to Larry a bit and TJ be more the expert, but when we're talking, I don't think it is enough to say where within the executive branch without a more detailed analysis. Because I mentioned, if you look at the organizational chart in the executive branch, there is the governor, there are the offices that fall underneath the governor, and then there's us over here. We receive administrative services. There's no direct line of communication with the governor. We do not exercise executive branch authority. I'd be interested in hearing the opinions of others, including the Attorney General's office, if they have one, including, the executive branch, if they have one. But there is case law out here, and I keep hearing statements that they're not part of the executive branch without an analysis of the case law that goes with this. We are separate. We are separate from other government agencies of the executive branch in the sense that we do not interact with the executive branch for anything other than administrative services. I think there are, in fact, other agencies, other commissions out there that were set up the same ways. For example, the Truth and Reconciliation Commission, I think in their, statute and information, they say, we're set up in the executive branch, but we are meant to be an independent agency, right? And this is common. This is not something unique Vermont has done. This is just something that we're pointing out because I don't think it has been discussed before. I don't want to take up too much more of your time, but I just want to say that the overall issue that we're dealing with here, we're talking about practical effects. So Betsy Ann mentioned enforcement powers. We don't have enforcement powers, but we do have hearing and investigatory powers. The practical effect of this is going to be when we get a complaint that involves a non-core legislative function, and we don't know that we can refer it over to the House or Senate ethics panel and have actual engagement about the issue, is that we'll retain it for ourselves and investigate it ourselves. And if we find that there's been a violation, then those findings will be made public. That is the practical effect of this. Unless you're proposing that the Ethics Commission no longer has hearing and investigatory powers, that would be a really big deal. Because last year, I'm sorry that the House and Senate ethics panel didn't feel like they had the opportunity to weigh in, but that was, not our responsibility. That was Legislative Council's responsibility. And so if something is not functioning, within that structure, that is not on us. But I do know that the legislation that was proposed last year outside of municipal ethics and outside of our input when it came to financial disclosures was drafted by Legislative Council, because the proposal for us to get these additional powers did not come from us. We agreed with it. We think it's important. We think it's very important when looking at the national landscape right now. I mean, ethics is under attack nationally. And so this is why we were so surprised to see the pushback for what is essentially just a requirement to consult. Let us give advice that involves engagement. A letter that signifies likely conduct that might violate the State Code of Ethics doesn't really cut it here, because that is not engagement, right? We don't know if the person who is receiving it views it the same way. We don't know if they're going to ask questions, to talk about the issue. And the whole purpose of not doing it at that first step is that facts come to light later. There's more investigation. There's more discussion on the part of the referral entity. And so the point is that after they've engaged in more discussion, when they have questions, they come back to us and we discuss it. And then we put something in writing so that they can have it as part of their record and they can share it with everyone else. Because a verbal conversation doesn't communicate the information in the same way. So this was our, kind of halfway point, recognizing that we do not have enough staff to go beyond doing the very basics of handling the very low level complaints where it's like, oh, I misused my email address. I tried to, there's an implied threat. I used my email address to try and, resolve a personal issue with somebody locally. You can say, okay, maybe that was inadvertent. But so what we will do is say, here, take some more training. We'll write up an agreement. You don't do it again, closed out. Or the big issues where there's no one else to handle those issues. That is what we are planning to do. And this is a middle way for us to be able to engage with the referral entities, to provide that advice, to make sure everyone is educated about the state code of ethics, because there's a lack of education with certain branches, I think, when it comes to state code of ethics. Yes, I was asked to speak about gifts 2 years ago, and I came in and spoke about gifts. I was not asked to speak about any of the other topics. I was asked if I could come in this year to speak during the training 2 days before the training was going to happen. I had a conflicting meeting that I could not get out of. Reminder, this is a part-time position. I work for a law firm. I do 65 hours a week at this point during the year. So I do need more than 2 days notice in order to be able to come in and give a training. And no, I was asked to review the slides. I limited it to what was in the slides when it comes to gifts. If I'd had more time and if I had, more ongoing engagement with legislative council, one of the things I have mentioned, internally with the Ethics Commission is would really like to see the legislators get more training, because lest they think that the only rules they need to follow are the gift rules, and the only rules they need to follow are, specific center rules, because there's also misuse of position, there's misuse of resources, there's all kinds of things that come into play that are not just gifts and do not involve just core legislative functions. And so when I hear legislative council talk mainly about gifts and give a training mainly about gifts and does not talk about all the other provisions of state code of ethics that apply to legislators that do not affect core legislative functions, that is where, for me, I see that there is a gap in understanding, and we're trying to address that gap in understanding. So what will happen is, if this does not pass, is when we refer a complaint to the House or Senate Ethics Panel, we'll say, here's the cover letter, here's your complaint, please let us know when you want the consultation. They'll come back to us, they'll say, okay, there's some additional facts, here are the additional facts. Maybe they won't. They'll just say, what is your opinion? We'll give them our opinion in writing. They can consider our opinion when they are judging the qualifications of their members. If this not go through, then we'll be retaining those complaints ourselves. We'll be investigating those complaints ourselves. They can lead to a hearing. They can lead to findings being publicly posted. This is in the public interest, especially at this time in our history. So my apologies, I talked longer than I planned to. I don't know if there's any questions, or if maybe Larry would have better information on the constitutional issues that he could share.
I do have a hand up, Representative Nugent.
Just to go back and clarify, you do agree that the way the law is now, no matter what number of days would require the legislature to consult with the commission before it makes its own process?
Yeah, they would be required to consult with us and ask for our advice. And there are a number of reasons why we don't see this in any way being a violation of constitutional powers. So we have done our own independent consultation with experts on Vermont constitutional law. We're hoping that at least one will be able to come in and testify. But there is case law talking about separation of powers issues in Vermont, talking about core legislative functions. And so I don't know how useful it is to do like a really deep dive into those cases, but I think we kind of keep hearing about Brady and Dean and nothing that's come after that. And I know it seems like this bill is a small thing, but the constitutional issue is a big thing. The accountability issue is a big thing. We hear from members of the public who are upset about things that are happening in legislature and government where they just feel like there's no accountability. And so this is the first that I'm hearing that they get their own closure letter. But when we refer a complaint, we get so many people following up with their office. Have you heard anything? Are they even going to be reviewing this complaint? It's just so opaque for members of the public. And so like we tell them, we are the ones who confirm for them, yes, they have your complaint, because otherwise they wouldn't know that the complaint, the House or Senate Ethics Panel is even considering the complaint. We hear from so many people who say, I have all this other information I want to share. I'd really like to explain this, but no one has ever reached out to us to ask us, why did you file this complaint? Can you testify? So I don't know if the House or Senate Ethics Panel ever, does independent research, independent investigation, asks people to come to testify. But I just know that people do not hear back from them once they file the complaint. and they don't understand the process, and they ask us for insight into the process, and I have to say, no, I don't have any insight into the process either, right? And so this is like the gap that we are just trying to address here, which it seems simple, but the constitutional issue is an important issue. And, like I said, we're very confident there are no constitutional issues with the consultation requirement. But at the same time, at the end of the day, you can do what you want. If you want to comply with this, you can comply with this. So why wouldn't you? It's just taking some advice that you can ignore or take to heart, but it's just getting advice from us. And the reason we're putting this forward is because we do not have engagement with the House and Senate ethics panels. We are not seeing that engagement. And so it leads to the perception that people don't want that engagement because they want to be able to close out complaints in a way that gives cover for people, to be honest. Whether that's happening or not, I don't know, but it does give that perception to the public.
Clock, I'm gonna give this 15 more minutes, 12:10. Representative Waters Evans.
Thank you. I'm confused about how there can be such a disagreement about whether or not the enforcement powers exist or not. Like if someone could point me to somewhere in a law or something that would say, yes, the Ethics Commission has enforcement powers, or no, it does not, or it doesn't specify it anywhere if the Ethics Commission does or not, then it seems like maybe that's something that we could and should clarify in future other legislation to make sure. But it seems, it's just confusing that there are two such different opinions about it, and that there should be somewhere, if it is clarified already, I'd like to know where that is, and if it's not, then, maybe that's a conversation for another day, but then, maybe we do need to make it more clear.
So this is the first time I've ever heard anyone say that we have enforcement powers. So this was discussed last year. We discussed it with Legislative Council because we talked about it in the context of the makeup of the Ethics Commission, because we do not have executive branch representation on the Ethics Commission. And so there was an agreement that if we were to ever get enforcement powers, the governor would need to have an appointee. Because we are not, this was the constitutional issue that was discussed last year. We have the power to hold hearings, investigate, and make recommendations. None of those are enforcement powers. So it does not specifically say the Ethics Commission does not have enforcement powers because it doesn't need to, because we don't have them. I've literally never heard anyone say before that they think we have enforcement powers. This would be the very first time. I have no idea where that is coming from, to be honest.
My other question is this. So I understand what the concern is regarding the Constitution, and it makes sense to me. I'm not quite clear yet what if this amendment, this H1 amendment, not that in its original form, but if this amendment that we're looking at would pass, if the core, if the essential action and function of the Ethics Commission isn't limited in any way, and it's not changed in any way, and it seems clear that Legislative Council thinks that this amendment clears up the constitutional issue while still allowing you to do the things that you've been charged to do, that I agree are essential and very, very important. But then where is the problem? You know what I mean? To put it bluntly, like, I don't understand, like, should this amendment pass? It seems to me on the face like it still gives the Ethics Commission the ability to do what it's been charged with doing, and it alleviates the constitutional issue, which is also very, very important, right? It's the connection between like why this would be really bad for the Ethics Commission, or not even the Ethics Commission itself, but like for ethics in general. Like, where's the issue then?
So first, it's accepting the counter argument, the argument that Legislative Council has been making is true, and it's saying, and it seriously limits the Ethics Commission's powers moving forward because all discussions are going to be seen through that lens. We think it is a false argument. this is an argument the Ethics Commission has been having since it was established. We're talking about what the Ethics Commission has been charged to do. The Ethics Commission was set up in response to, national surveys that found us to be at the bottom of the entire country when it comes to ethics. People did not want an ethics commission, right? They set it up so that we could say we had one, because that was one of the biggest things. They don't have an ethics commission. So we're set up with an ethics commission, one part-time director, well, eventually Larry Norvins, but we were set up with no powers. There was no state code of ethics. So if you're looking at, what the ethics commission was set up to do, when the ethics commission was set up, it was set up to give general advice. When I started, people would call and be like, well, I have this problem in my office, what should I do? And it would be like, philosophical. Well, what are ethics? You know what I mean? So the Ethics Commission was set up to have no powers, to have no teeth, to have no ability to truly function. And the process that we are in now is turning us into a real ethics commission, like exists in other states, like existing states that are more advanced than us when it comes to ethics accountability. Because I do think in Vermont, the situation that we are in is people feel like, well, I know that person. And so we don't want them to get in trouble. They wouldn't do anything wrong. We don't need this. And we hear that argument over when it came to the Ethics Commission. We don't need this. Why do we need a state code of ethics? We need a state code of ethics because not everyone acts in the way that they should, and not everyone knows, I'm not saying intentionally, they're acting the way they shouldn't, but some people just don't know. So they need to get those advice, and we need those guardrails in place for when people do go off those rails. And so, but that is not, the original intention of the Ethics Commission. If we were looking at only what was the purpose when it was set up, is so different than, what we have now. So we're in a process of growth. We're in a process of slow growth. And what I'm saying is, okay, if you decide that, you don't want the consultation requirement, you don't want to take the advice, I just say that looks really bad because you can do this if you want to do this. It looks really bad to the public. It looks really bad to the public at this time, in history. But the practical effect is that we're going to be conducting those investigations that would normally go over to the House and Senate ethics panels. So is that the result that you're looking for here? Because that is the practical result.
Madam Clerk, please stand.
I just want to address, I addressed the commission's new investigative and enforcement authority on page 9 of the memo, under subsection B, entitled New Commission Investigative and Enforcement Authority. And what that is referring to is the commission's new power to investigate, that includes subpoena authority, hold a quasi-judicial hearing, and issue warnings and reprimands when the commission finds after a hearing that it has a violation of the state code of ethics has occurred. And so warnings and reprimands are a public document. It's a public statement by the commission that there has been a violation of the state code of ethics, that a public servant, any public servant has violated the state code of ethics, similar to, for example, a finding by, my experience, professional board finding that a licensee has committed unprofessional conduct. That is their enforcement authority.
That is not enforcement authority. Enforcement would be if you remove someone from
I had a
office.
hand up from a member. Representative Wood.
I was gonna say that it seems like that this authority that is going to be set effect in September of this year would then take away our legislative power. Not take away, but replace our constitutional authority.
So I want to acknowledge the current statutory law of the commission acknowledges that the commission does not abrogate the authority of the House to judge the qualifications of its members. So there could be two simultaneous processes. If there is a violation of the state code of ethics committed by a rep, for example, the commission would be able to adjudicate that complaint. For example, a violation of the gift statute, because there is limited, no Vermont case law that I'm aware of about what constitutes a non-core legislative duties. But for example, a Nevada case that interpreted our Brady v. Dean case did at least provide some context for non-core legislative duties. And gifts, accepting inappropriate gifts, for example, would be a violation of a non-core legislative duty. The commission could adjudicate that complaint. Simultaneously, the House Ethics Panel could also find that a member did not inappropriately accepted a gift. The enforcement is that, what's the result of both? It's a public admonishment. It is saying, as a public statement of the commission, that a rep, for example, did violate the law, and therefore we're issuing a warning or a reprimand. the ethics panel or the House's authority to enforce is also a public admonishment. It's a form of a censure, for example. The House has one step more authority in that the House has the authority to expel its members. That is the House's enforcement. That is an enforcement power of the House. So it could be that those two complaints are moving simultaneously. What the commission cannot do is adjudicate complaints that involve core legislative duties, which includes things like whether a member should have voted on a question, whether a member should be placed on a certain committee, that goes to conflicts. And then we don't know yet where the commission feels the line is. If you look at the state code of ethics, there are definitely, in my mind, gray areas about whether a member is holding, for example, a job outside of the legislature that conflicts with their legislative duties. In our perspective, the Constitution controls that. I don't know whether the commission would attempt to interfere with the legislators outside work duties. I don't have that information from the commission. I'm just raising, there are gray areas yet to determine about where that line commission sees between core and not core.
That specific example came up when the code of ethics was discussed.
Hold on, I'm calling intern. I see a hand.
No, I'm done.
That specific issue was discussed when the state code of ethics was discussed. It was discussed during government operations. And it was clear that outside employment that might conflict with core legislative functions was not something that would fall under the state code of ethics and our authority for the purposes of, advising or finding a violation under the state code of ethics. So that was made very clear during the discussion of the state code, that specific example.
Representative Tango.
And I'll
And
just
then
make this,
Council O'Grady.
I'll just make the same comment that I did when we were talking about this, the last biennium, that I don't understand. This is a comment, not a question. I do not understand the lack of conflict of interest with outside jobs and being a legislator where you might be directly involved with funding an organization that your family member works for. So I just needed to put that out there again.
Thank you.
Mhm.
Council.
So I think one other potential gray area is misuse of office. Because the ethics panels have reviewed allegations against legislators that they misuse their office. But that's also a standard under the State Ethics Commission. I don't know where the commission draws that line or if it was discussed when the commission was last year.
No, okay.
Do you have something to? Yep, I'm ready.
That's going to be a fact-based pattern, right? So there are situations where somebody can misuse their office when they're clearly acting in a personal capacity, but using their title or using government resources to gain a personal benefit that is not related to core legislative function. Then that is when something isn't going to fall under the purview of the state code of ethics. And so, whenever we talk about ethics, we always get into a lot of speculative examples. But when people are working together the way they should be working together, which is what the purpose of the consultation requirement was, it was so that we could work together and engage on these issues in a professional manner. And so when these issues arise, the normal course would be to have that conversation and ask, what is your viewpoint? This is our viewpoint. But again, these are questions that are not going to, they might be questions of first impression for Vermont because we only have state code of ethics so recently, but they're not, cases of first impression nationally. And a lot of our code of ethics was taken from the federal code of ethics. So there's a lot of case law out there. There's a lot of discussion about this. We're not, making things up as we go along. Like we're using actual references when it comes to things like this. But an example of misuse of position that would not involve a core legislative function is somebody writes a recommendation letter for their child on their, legislative letterhead, signs it, doesn't mention that the parent of the child, and gives a recommendation so they're, kid can get into Harvard. They're saying, Representative so-and-so, I think this kid is amazing. He's wonderful. Look at all his grades, blah, 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 blah. And they make it seem like they are, doing it in their official capacity. It carries the weight of an official position, but that is misuse of position. That is not related to core legislative function. Function is giving the recommendation. Anyone can give a recommendation for a kid to get into school, right? The misuse comes in when you're making it seem like this is an official government position that we, support this child's application to Harvard. That's the distinction there.
So a couple of things, fact-based determinations are always going to lead to different interpretations by different bodies. So there is opportunity for overlap. In addition, misuse of position is something that affects the integrity of the body, which is a standard that the House and Senate use for its jurisdiction over the behavior of legislators. So in the example that was just provided, I think that is something that's within the ethics panel's authority because it reflects on the integrity of the body as a whole.
Representative Nugent, thank you for your patience. All right, I am gonna say we're at 10 after. I'm giving this 5 more minutes. Representative Nugent.
It sounds like to me that the core legislative functions are implied right now. They're not defined clearly. Is that what I'm hearing?
Defined in case law. There are definitions out there. There's, I think if you look at the,
Not in statute.
not in statute, they're referenced in statute, but they're not defined. But, this is how the law works, right? Case law interprets statute. So you're not going to find an answer for anything, every single question in a statute. That's just the way the law works. And so you're saying there's different interpretations. Of course, there's always different interpretations of the law, because if there wasn't different interpretations of statute, we wouldn't need the court system, right? But that's not a reason not to pass it.
Any other comment, questions? Please.
Thank you. I'll try and focus on each one rather than the broader picture of the Ethics Commission. And the issue of separation of powers, and in my brief time, and I thank you for the opportunity again, I'd just like to add something I didn't say last time, and that is I was a state employee for over 30 years. I was head of the Public Defender's Office in Rutland and later on in Addison County for 15 years. I worked for the Office of Professional Regulation for another 14 or 15 years, actually worked at CN. And during that time, conducted administrative hearings, did some drafting of things that we sent over to become legislation later on, drafted administrative rules, got them through ICAR and LCAR, and appeared before this committee many times over the years. Also been teaching at Vermont Law School for the last 20 years. Teach trial practice, part of the evidence course, and I've taught administrative law for the bar review when that was still a bar review course. I was appointed by the Vermont Supreme Court and served 3 terms on the Professional Responsibility Board. And then after that, I was the executive director for the Ethics Commission part-time. It was toothless. If you Google me, what will come up is Novinsky Prize Toothless Ethics Commission. So what 1223 does is it is a delegation in a way of legislative power, or legislative authority. And it says to the Ethics Commission, we would like you to do something for us. I reviewed many of the Vermont Supreme Court cases that talk about separation of powers. And the question always is whether the power used by another organization or another branch of government is encroaching on a core function of either the legislature, the judiciary, or the legislative branch. So what 1223 does is it directs basically gives the Ethics Commission the duty to share its expertise on the meaning of the ethics code with the House or the Senate ethics panels. It's information that it imparts when they're asked for consultation. It's confidential and it's non-binding. So I agree with what's been said about the Vermont Constitution provides for separate and distinct bodies, that neither is to use the powers belonging to the other. But our Supreme Court has held that absolute separation of powers is not required or even desirable. And case State versus Pierce from 1995 talked about, they quoted Hamilton talking about why separation of powers is necessary, but also checks and balance are necessary. And it also speaks of when there's an overlap where one branch is exercising a power that belongs to another. It's okay if those powers are incidental to the discharge of what they're doing. So what we've done in 1223 is ask the Ethics Commission to, when asked for consultation, give the legislative ethics panels their idea of how the code applies to the particular facts at hand. It's what they do all the time. This extra opinion is incidental to what the Ethics Commission does anyway. It could have come as a request for an advisory opinion. It could have come to the Ethics Commission as a request from an individual. Am I doing the right thing or not? So what the Ethics Commission does when it consults, when it's asked to consult, is the same thing it does anyway. So the Ethics Commission is not exercising any power that it doesn't have, especially when we remember that the consultation results in what? A written document that is non-binding and confidential. So there have been many times in Vermont history where there have been questions about powers given to other parts of government are illegal or not, or violation of separation of powers. The legislature, the General Assembly, gave the Secretary of Administration and the Joint Fiscal Committee authority to prepare and implement a deficit reduction plan. What happens if there's a deficit and we need to act immediately? Was that a violation of separation of powers? Supreme Court said no, it wasn't, because there were guidelines and they were accountable for what they were doing. The legislature gives OPR, where I worked for many years, where Betsy Ann worked for many years, the ability to draft administrative rules. I drafted rules for probably 15 or 20 different licensing organizations. We have that authority. It's a quasi-legislative power. Why can we do that? Why isn't that a violation of separation of powers? Because there are guidelines for it, and because it can be challenged, because we confer with the state, with LCAR and ICAR before these things go into effect. Administrative agencies hold hearings and adjudicate rights. Why isn't that a separation of power? Because they're accountable. They have guidelines and it's appealable eventually to the courts. The legislature, this is interesting, we talk about separation of powers, legislature can't affect core judicial powers, but it can create courts. And it does that. And it can add courts. It can take courts back if they want to. They can delegate, they can dictate what the penalties for criminal statutes might be. That's not an imposition on anyone. So how would the Supreme Court, I mean, that's basically, we're talking about this is a constitutional question. How would the Supreme Court look at this if they ever got this? And it's hard for me to imagine how this would ever get to the Supreme Court unless the House Ethics Panel decided to appeal the application of this bill. But all bills that come before the Supreme Court when there's questions of constitutionality, they start out presuming that it's constitutional, unless and until somebody can show that it's not.
Representative Waters Evans.
So listening to all this, it seems to me like there's a really big issue, right? Which is the Constitution. And, you know, we're all here sitting around this table, at least this section of the table, because we made an oath to uphold the Constitution, right?
Right.
The state of Vermont. And so if that's our primary goal as legislators in our function, then it seems like inherently the advice that we're getting from legislative counsel is that we're actually not doing that if we don't pass this amendment. That's kind of what I'm hearing, right? So then my question for you would be, either one of you, it seems like if there are two issues, there's this big one of the Constitution and what our job here is, and making sure that we are not that we're not giving authority that we don't have the ability to give to the Ethics Commission. Then I'm hearing also that there are a lot of smaller in quotes, because none of them are small really, they're all very important. But would those smaller issues, would solving those smaller issues be impeded in any way by passing this amendment and saying, okay, we recognize that there's a problem here, that this is the way to solve it, and would that create a barrier that can't be overcome in solving those smaller issues?
I mean, the question here is, would the justification for passing H1 be separation of powers? Is that the justification that you're using? And if so, then that is the problem. If you're saying practical effects, but we don't see a constitutional issue here, then that would be a separate issue, right? You'd just be losing the benefit of the Ethics Commission's advice, and the public would be, losing the benefit of the Ethics Commission weighing in to make sure that, complaints were, considered properly. But the constitutional issue is the issue.
Okay, thank you. I mean, I don't know if this is a problem we can solve right this second, and we are also out of time. But I appreciate the enormity of the issue, but also appreciate the fact that we do have a limited period of time to fix it, or to not fix it, but to answer these questions, I guess. Anyway, I think. Sorry,
So we are
thank you for letting me
way
ask
past
you.
time, so we
Sorry.
are calling it for the day. I appreciate everyone's time on this dense subject matter. We